Okay, welcome everybody. This is Marcus from the Oregon Coast Visitors Association. We're gonna jump right into the free IP tutorial. So take it away, Joe.
Great, thank you, Marcus. Nice to be here with everybody and those who join as we go on. Marcus asked me to kind of just do a primer, what I've called Intellectual Property 101, on the various ways that we protect concepts and intellectual property, non-regular property. I'm representing a firm called Rational Unicorn, and this presentation that I'm giving, you're all going to get a copy of it. So there's no real reason for you to have to take notes or anything like that, or worry too much about reading everything in it. But we're a West Coast-based firm that really relationship oriented towards organizations and folks who might otherwise not hire lawyers, or for whom the big firms aren't right, or things like that. And my specialization is in areas of entertainment law, intellectual property law, and corporate startups. And I've worked with a lot of organizations that are doing some of the exciting types of things that this project is. I've been around for a long time. I've been practicing for over 30 years. I started off in a large San Francisco firm, and then moved on to my own work, and just really excited to be able to be here and talk to all of you. Disclaimer here, I'm not giving any legal advice today. This is just to discuss the basics of the main groups of intellectual property, which we'll talk first about patents briefly, then about trademarks, then copyrights, trade secrets, and then we'll leave some time at the end if there are going to be any questions that you all might have had. If there's something that comes up on the way, just unmute yourself and shout out. I can't probably see all of you, but if there's something important and you want to interrupt, this can be interactive as much as you want. I don't have to be just a talking head. But let's start off with patents, and that's something that everybody's kind of somewhat familiar with, right? You patent inventions, and that's right. And what you'll see is a big distinction between the protection of and by the way, I should say all of these rights are essentially monopoly rights. Under the Constitution, Congress was granted the right to grant to inventors and authors and artists and things like that the right to have a monopoly for a period of time on their intellectual properties. And that was to encourage people to go out and invent things and benefit. The society benefits from them, they benefit from them as well. So patents are ideas. And they're basically the patent owner, the person who comes up with this original idea, gets to have a monopoly on it for about 20 years. And there's a couple of different kinds of patents. There's three really, but there's two that we'll mostly discuss. And they're for new, useful, and non-obvious inventions. Right? So it has to have that kind of, hey, nobody's ever done this before. Nobody thought of this. Sometimes it could be incredibly complex that nobody thought of it or did it. Sometimes it can be incredibly easy. Just like, oh, wow, the light bulb goes off and you've got a great idea. And they fall into a few categories. Utility, which are the ones that we think of most of the time. That's the invention, from the automatic hat tipper to the windshield wiper blades that are intermittent. That's one of the famous patent cases of the man who invented that had to pursue it for quite some time. Those can include processes, machines, manufactured items, like I said, or even formulas and compositions. So most everything generally falls into the patent realm, and we'll talk about that a little bit more. There's also design patents, which are sort of the way something looks. There are times when the way something actually looks can be patented. And then there's plant varieties. And we're not going to talk about plant varieties at all today, but the truth is horticulturists who create new plants from other plants can actually patent those as well. Okay, so I used one of the clusters diagrams here to sort of show, some of the various ways. You can see all of the different things that can be made from fish. And this was fascinating to me. That's why I love the work of the Oregon Coast Cluster is to, all of these things that can be done. Well, many of them may actually relate to something that could ultimately be patented. Most of them probably in the utility realm. And as I say here, for example, if you created a new kind of canister that kept fish, fresh longer or something like that. So originally, like, let's say probably the original zipper, although it's too old, but like a Ziploc bag. That Ziploc idea, somebody came up with that, and they had a patent on it for a while. That's the type of invention and that could be made that's not necessarily relates to the products themselves, but how the products get to market, how the products are prepared, whatever it might be. So if you have that kind of original, like, wow, this would be a better way to do something. It's the classic better mousetrap, right? This would be a better way to do something surrounding this, then that could be a design patent. You could also, the chemists out there can also create compounds or formulas. I noted here, perhaps a specific enzyme that can be developed and used in a specific way. Where it's like, yeah, we noticed if you do X and Y, in fact, I recently had a situation where they added sugar to something that nobody had added sugar to try to create a particular result. And it worked. And that idea, that eureka moment of, why don't I try this? This might be different than anybody's ever done before. That idea, as simple as it was patentable. And so, that's how you protect those moments where, you have something of that aha moment. Also applies to software. Software gets a little confusing because there are lots of code, and those could be subject to copyright as well, which we'll talk about later. But overall, if you have an original, unique piece of software, that can be subject to patent. Another example, again, here is, perhaps a method or formula that goes into medicines. Medicines are often patentable as well as the devices that deliver them. Like I remember when there was a patent on albuterol, which is for asthma, and then that patent ran out because patents last about 20 years for the most part. But they started repatenting different devices for its delivery. And so you kept having to pay high prices for what was now a generic drug, but that's because it was being delivered by a new patented method. So these are that's the basic ideas of the utility patents. The design patents, those are more ornamental, I should say. So, you could patent a particular style of bottle. Or in fact, one of the companies I worked for a long time created a new kind of bear spray that had what was called a pistol style spray head. And that was patentable. And they made, basically a better pepper spray because there was nothing different about the pepper spray in this case. More on that later. But there's nothing different about the pepper spray. It was, again, the method of delivery that was a pistol style. See where my hand is, instead of a spray style. And that was a new original idea, and it was patentable. But not only was the idea a utility patent of this is how it works, this structure, but the look and feel of it was also a separate design patent. So people couldn't actually even make anything that looked like it for a period of time. Same with user interfaces. I had mentioned a decorative pattern sometimes are patentable, but that's the basic idea there. Now, as I said, design patents, those are the ones of protecting what it looks like. They last for 15 years, don't have to renew them. It's a one-time thing. Utility patents take a fair amount of maintenance. There are times, and you'll see here between years 3 and 4, 7 and 8, and 11, 12, that you have to update them, you have to pay fees. Patents are not cheap. Patents are expensive, and they cost a lot in terms of attorneys because it's a specialty section of the bar, and they tend to cost a lot to upkeep and to get them in the first place. They can be very powerful intellectual property, but that is That is the reality around a patent, is they tend to be quite expensive. Also, one important thing before I kind of wrap up on patents, because it's not my area of expertise, and as I said, it's a specialty of the bar. So, I just want everybody to understand kind of what they are. One other thing is, if you do invent something and you think it's patentable, you have to register your patent. It doesn't have to be granted, but you have to apply for your patent before it's been in commerce for a year. If you put something out there and it works for a couple, 3 years, and you're like, hey, wow, I should really reserve the rights to this, you've already lost your patent. So you'll see a lot of people put them out before anything's even commercially out there. And the vast majority of patents at the United States Patent and Trademark Office are actually worthless. They probably never even came to commerce. It was like, got this idea, let's patent it. But again, it's a specialty area and can be a little expensive. So, I can tell you a little bit more. We do have a specialist at Rational Unicorn. It's not me, but who can help if you have those kinds of questions concerning these kinds of intellectual properties. All right, now let's get into the ones that I think are probably generally more applicable to the companies that are involved in the cluster. The first is trademarks. Now, trademarks are different than all of the other ones, and you'll remember I said there's a monopoly involved. Well, it's not just for the owner in this case. Patent protects the owner, copyright protects the owner, trade secrets protect the owner. Trademark protects both the owner, because it can be their most valuable asset, their brand, but it also protects the public. It protects the public from fake, pirated objects. It allows them to understand, or to count on the origin of the goods or services offered. And as a result, there's a certain balancing act between the public interest and the private interest in respect of them. Now, trademarks are created by use in commerce. So you have to actually put something out there with the name on it for sale in interstate commerce, which is really easy to do these days. And once you do that, it can be a logo, it can be a phrase, it can be a design, it can be a color. Tiffany blue is actually a trademark. Nobody else can use that exact shade of blue but Tiffany, at least not in sort of a jewelry context. Lots of things can be trademarks, but they have to be distinctive. They can't be just generic or descriptive. They have to be distinctive. The more distinctive, the better. The classics are words that were just totally made up, like Xerox or Kodak. Words that, that don't mean anything, that come to be associated with certain goods or services. Those are the strongest trademarks. And if it's a generic word, it's not a trademark at all. If it's just beyond generic, it might be a very weak trademark, okay? The thing about trademarks that makes them different from copyrights and patents is that they can last forever, right? It can be your brand and it can last forever because as long as you are continuing to associate it with the goods or services involved, then you can continue to protect it. So registration of trademarks is vital, probably more important in the trademark world than in any other field. You really do want to, once you start using a trademark to describe the origin of whatever goods or services you are creating, not only are you going to want to do things like a DBA or whatever it is with your local state Secretary of State, you're going to want to file with the United States Patent and Trademark Office. First off, for a couple of reasons. You're going to first want to do a search and then second, file. The reasons are, whoever uses it first in commerce and can prove they use it in first, for the most part, owns the rights. So you have to make sure that you're not accidentally infringing somebody else's existing trademark. So that's why it's really important to have somebody do a professional search for you. We do those on a flat fee basis and make sure that you have come up with something that's original, that's not going to be confused with somebody else. And then once you do that, you want to register that and you want to make sure that you maintain it essentially by keeping track of your own mark and how it might be being used. And if you see anybody using it, sometimes you'll see these cases where you're like, oh my God, why is this company picking on this little guy about the trademark? And the answer to that is they have to. They actually have to. The way you protect your trademark is by zealously sending cease and desists or suing anybody that uses it, whether it's accidental or not, essentially, right? You have to protect your trademark. And so you do see, like, for example, I had a case early in my career that shocked me. It was a company called Dandy Doggy, and they made pet food. And they had a product called Chow Mein, which was cute. It was a vegetarian dog food. And the Purina company came along and said, we own the word chow. And I thought to myself, that can't be right. They sure do. In fact, chow, as we use it to just mean food in general, is because GIs used to call their food chow to insult it in the army, because chow is actually an invented word by the Purina company to designate the origin of its cattle feed, its original cattle field. And they really do own the word chow. And so they were great about it. They actually paid my client to change to something else. They didn't really want to hurt them, but they had to do that kind of thing. So you have to keep scrupulous attention to your trademark. Again, it can be your most valuable asset as your brand, and they have to be renewed. The first renewal is the most important one, because if you renew after 5 years and can show continuous use, then it becomes incontestable. And somebody from way earlier that never said anything about your registration, who was not registered themselves, can't come along and suddenly say, hey, wait a minute, you violated my trademark that I've been using for years, but I didn't say anything about it. And it also becomes incontestable with respect to what's called secondary meaning, how original it is. So again, monitoring and enforcing rights is extremely important in trademark, having it registered. And the difference, by the way, just so you know, everybody always asks about the circle R and the little tm. The circle R means you have a registered trademark with the United States Patent and Trademark Organization. TM doesn't really mean anything. It means that you are saying, hey, I want to establish rights to this. I'm claiming rights in this under the common law. But it really has no actual effect at all. It's okay to do it, especially while you're waiting for the registration to issue on your trademark. But the actual little TM doesn't have any real legal value. You want to register your trademark and get the circle R, and then you want to maintain continuous use of it and continue enforcement of it throughout the time that you're using it. And some organizations, they'll use one for a while and they'll kind of stop using it, but they'll sort of be like, wait a minute, we have to do certain things to maintain some use of this to protect it, so nobody comes along and uses one of our old trademarks. They can be really valuable. Okay, we'll move on now from trademarks to copyrights. Copyrights are the expression of an idea. So the patent protects the idea itself, right? The invention, the design, whatever it is, the idea. Copyrights protect a specific expression of that idea. And it has to be original. It's called an original work of authorship. And it has to be put in some tangible means of expression, written down, painted, recorded on a sound recording. Digitally, we can make lots of things fixed in a tangible means of expression now that we once didn't. But yes, it's the idea is it becomes a copyright when you actually fix it in a tangible means of expression. Now, it used to be back years ago, before the 70s, that you had to then register your copyright in order to protect it. And for old copyrights, and I mean before 1976, that's true. But since 1976, they changed the law, and copyright adheres in the author. person who's responsible for the creation of it, usually the actual person, but we'll discuss works made for hire in a moment. But it adheres in the author upon the moment of creation. If you actually look at the copyright register's logo, it's like an old fountain pen poised it's sort of in the air. And if you ask a copyright practitioner, they'll tell you it's coming off the page because what is written has been completed and the pen is actually coming off the page. So that's when copyright occurs. And you own that copyright, period, right? However, registration of it with the Copyright Office is a good idea if you are at all concerned about somebody infringing your work. Sometimes people don't really care, or if they are infringed, they can still bring a lawsuit later, but in order to sue for infringement, you must register your copyright. So that's the first thing, is it's a jurisdictional prerequisite to suing to protect the copyright, is to go ahead and register it. And if you have registered it prior to the infringement taking place, you can claim all kinds of extra damages, right? You can claim attorney's fees, you can claim statutory damages instead of having to prove damages. So registering it is a good idea. In the old days, you also had to put the circle C, that means copyright, as opposed to the circle I, which is registered trademark. Circle C, the name of the copyright holder and the year. It's still a tremendously good idea to do that, for the same reason it's a good idea to register the trademark, because that will allow you, in the instance that someone infringes your copyright, to get attorney's fees and potentially, statutory damages. So if you publish it with what they call requisite formalities, that gives you more rights. You don't have to put that on something to have a copyright in it. You used to, but you don't anymore. But it's a good idea. So I guess I should have had this page up. Sorry. So again, like this is an example, copyright, Circle C, Rational Unicorn 2025. That's, if that's on this particular PowerPoint, then we are letting everybody know that we own the copyright in this PowerPoint. And if somebody were to infringe it by, for example, publishing it beyond the rights that we certainly granted to the cluster, and obviously we don't really care, right? We're happy for people to have this. But let's say we weren't, or somebody wanted to, this were more confidential, or it was something that was really original, then having that there gives you the additional rights that you might want. Copyrights are great because they last a long time. Patents, maybe 20 years. Trademarks can be forever, of course. But copyrights, if you can copyright something instead of patenting it, copyright it. It's cheaper, it's easier, and it lasts a lot longer. Life of the offer plus 70 years, or, essentially a lot of them wind up lasting 95 to 100 years. And it also depends. Internationally, they tend to be a little bit longer, but they last a long time. And it used to be that you had to renew them. You don't anymore. It's one shot. Once you have your copyright, especially if it's registered and everything like that, it's good for a long time. So it's great for, if you create something that creates money for a long time, like a novel or a song or a recording, your great grandkids can very well still be clipping coupons off of it at the end of the day. So notice and registration we discussed. Again, same thing here in monitoring and enforcing your rights. Making sure, and this is especially true in the music business, where digital distribution of music made it where everybody was using everybody's music and nobody was paying for it, and they created whole industries around keeping track of that, and issuing cease and desists and takedown notices and things like that. So, depending on what kind of a copyright you have, again, you do want to monitor it carefully to make sure that nobody is violating your rights. Easier to enforce copyrights. A good cease and desist letter will often do the trick. But again, you have to know that it's being infringed or potentially infringed. Unlike trademarks, the fact that somebody got away with it and somebody else doesn't is irrelevant. So it's not like you have to sue everybody under copyright. It's just a good idea, obviously, to monitor and enforce all your rights. And one of the ways a lot of people do that is they actually have somebody else do it, right? They license certain of their rights in copyright to whether it's a publisher or in the music business, a performing rights organization that then goes out and collects all of the money that's owed because your song was played on the radio or things like that, and they do it for you. So actively licensing and using your copyrights is one of the best ways to enforce them. But there also are other organizations that will help you keep track of digital rights. Okay. And then and I think this could be somewhat interesting to various organizations in the cluster, is trade secrets, because trade secrets can be really powerful where you may not feel that you are going to get a patent, right? Maybe what you're doing isn't that new or that useful, but it is different or it is special. Or you even just want people to think it's different or special. You know, the Kentucky Fried Chicken, 7 herbs and spices or whatever it was, that was a famous trade secret, still probably is. I mean, can other people recreate it? Yeah, they maybe can, but the idea is if you have something and you are able to keep it secret, and it often is things like formulas, but it can be customer lists. It can be methods of doing business, can be all kinds of different things. As long as you are able to keep it secret, trade secret can be an excellent protection. So the first thing is to determine, hey, this is something we want to keep secret. And then the second is to implement controls to make sure that everybody knows it's secret. And that's where NDAs come to play, non-disclosure agreements, making sure that anybody that you're dealing with knows that the materials that you may or may not be sharing with them are trade secret materials, that require that they not reverse engineer things, that the only people who have access to them are sort of on a need-to-know basis. And you'll see in the world of corporate trade secrets, the kind of high end, this is the world of sort of industrial espionage. Is how do they do that? How do we get a hold of this information that they have or this formula that they have? Because when you patent something, let's make this clear. When you patent something, you tell everybody exactly how you did it. That's what the patent application is. It says, this is exactly how this invention works. And I created it. It's new, it's useful. And I want a monopoly on it for 20 years. Great, right? That's terrific. You can do that, you can get that, but the whole world knows how you did it. So the second after that patent ends, you can then create generic versions of the same thing. One of the reasons trademarks are so important, right? If you have a trademark then that says, you can basically say, accept no substitute. You've been buying this stuff for 20 years. Ventolin, just to go back to my asthma inhaler example, you've been buying Ventolin for 20 years. You should keep buying Ventolin. We're just like, yeah, except for that I could pay less for albuterol, which is what it actually is, the generic version of it. And people can make generics. They can start copying you. So your trademark may be valuable to sort of continue to tell people, hey, I'm the ones who originally had this, even though the patent isn't protectable anymore. Trade secrets can last as long as you can keep them secret. And they can be involved with your trademarks as well. So the key to them is actually doing all the things, whether it's with your own employees or with businesses that you are working with, to make very clear that you have certain things that you may discuss. You may discuss them even in general. You may discuss them in specific, but that are your trade secrets. They are your property. Customer lists are really a big classic example of this. But also sometimes it's plans for the future. All of those kinds of things, you want to make sure that you have proper protections in place if it is something that you want to keep secret, and consider secret, not just like in, well, it's good, not everybody needs to know this, but as in, this is a fundamental property right, a fundamental advantage of our company. And courts will enforce those those types of non-disclosure agreements, confidentiality agreements. They'll enforce them against employees. You can get injunctions and so on and so forth. So that's basically going through the distinction amongst, and again, trade secrets you obviously don't register. Those are entirely based in contract, based in the way people work with one another. There's no governmental enforcement unless and until you go to a court and you ask them to enforce the contracts. So those, it's important to also have, good contracts in place, that you have a good NDA that covers you, that you have the proper types of employment agreements that cover information that you might share with your employees and things like that. So trade secrets, contractual in nature. Copyrights, inhere in the author at the moment of creation. Registration is sort of optional. It's a good idea, but you don't have to do it. Trademarks, definitely want to register them. And patents, again, a little bit more complicated, a little bit more expensive, but if that's what you're looking for, is that 20-year monopoly, those also have to be registered as well. So that's the basics of those 4 areas, and I had wanted to leave about 20 minutes for, let's see, where are we? We're doing pretty well, actually, for questions, but I actually think, I think we're there. I think we might do better just to have everybody ask questions about anything that I raised, or anything else that comes up, anything about Rational Unicorn, or frankly about the cluster. I think Marcus could answer questions as well.
I have a question. This is Lamar with the South Coast Development Council.
Hi, Lamar.
My question is, when we look at these different types of digital content and created works and things of that nature, I guess my thing is, how does that apply to AI-driven um, collaterals? For example, if you were to use AI to go ahead and put in, to create something, guess I'm wondering, if you're using Chat GTP for an example, would any copyrights or trademarks through you using Chat GTP, would that affect your process of trying to register or trademark, what you've done or created? Or would there be anything that might supersede what you're trying to do because you're using that particular AI tool?
Right. That is such a good question. And to a certain extent, the answer right now is we don't know, because the law is lagging far behind technology, and this always happens in intellectual property, but it's happening in a big way now. And actually, Lamar, I'm so glad you asked that question, because thinking about it now, it's probably something that I should have actually included in. Hey, by the way, this is the modern thing. I haven't done this in a little while, so I'm really glad you asked that question. The answer is, with traditional copyright. Oh, and by the way, I didn't talk about works made for hire. I mentioned it, but I didn't talk about it. So let's go back to copyright. The author, right, the person who paints the painting, that or writes the novel, that person owns the copyright, unless it is a work made for hire. And works made for hire can be of 2 types. A regular employee, it was your job to do this, and I paid you as my regular employee, and you have a W-2, and it was your job to create this stuff. I therefore own it as your employer. That's a classic work made for hire. Or a specially commissioned work made for hire, which it means it has to be in writing. And it says, regardless of whether you're an independent contractor or not, I hired you to do this, and you are creating it at my behest. And it's just as if I were the actual author. Okay? So, so the point is, copyrights, and AI is I think more significant right now in the copyright area. So let's start with it. There's going to be some patent stuff too, but copyrights, you're creating new materials, will belong to the owner of something new and original. Now, the position that most people take now is if you are the person that inputs the request into ChatGPT to create something sort of on your behalf and you edit it or you do whatever you work with it, but you're asking it to create that, then you're still the author, right? Because it's like it was your helper, but it was still associated with you. Now, issues are going to arise with that over a number of things. One is the issue of, well, how did ChatGPT get its ideas for how to do what you were doing in the first place? And of course, lots of places are already suing. The New York Times and others are actually suing OpenAI to say the way you trained ChatGPT was to feed it all of our copyrighted stuff. So it internalized all that copyrighted stuff, and it now copies it and infringes that copyright by spitting it back out in various different ways. Incredibly complicated issue. One that, again, the courts will undoubtedly begin to address, and they're going to have to address with new information or new legislation at some point in time. But aside from the fact that what ChatGPT spits out may violate somebody else's copyright, it's still working on your behalf, or the fact that it may have violated it when it took it in, right? When it spits it back out, it's still working on your behalf. And especially when you edit things, when you make decisions, all of those types of things, I think people still are going to have a very good claim to copyright in the materials that they get out of ChatGPT that they work with the caveat that ChatGPT may spit something out, and if you just copy it and you put it out under your name, and all it's done is copy somebody else, and what you put out thinking, okay, I'm putting this out here, it may well be infringing of somebody else's work. We'll say, I don't care whether you got it from ChatGPT or not. What you actually put out is the same or strikingly similar to the ideas that I originally had in my prior copyright, and your doing so has infringed my work. So I think the most important thing that we can take out of using AI at this point in time is that you try your best not to just cut and paste in whole, right? Or in large measure. Now, let's say it's art, right? And you're telling ChatGPT to create certain kinds of artwork for you and things like that. My guess is a lot of those are going to be fairly original, or it might be weird, but they should be fairly original. And again, the more that you're interacting with it, the more it becomes a tool and the more it's actually expressing your ideas and helping fix those ideas in a tangible means of expression. And again, it would be yours. So I think the biggest fear, not even fear, I should say, red flag for authors or creators or business owners is simply that you not use ChatGPT as a stopgap for original creativity, that you use it as a tool, as a helper, but that you take the time to interact with the product it puts out enough that you feel confident that what really is going out there is what you wanted to create as your original work. Does that make sense?
Yes, thank you so much. I really appreciate it.
Absolutely. It's a great question. I'm really glad you raised it. Thank you. Other thoughts or ideas from things that I might have covered but didn't?
This is Ivan Sultan with Columbia Bar. I have a question, and you may have answered some of this, but my late arrival skipped that. I have a process authority approved manufacturing process. And since I created it and it's written, essentially it sounds like what you're saying is it's already copywritten. Is that accurate?
Actually, it's copyrighted.
Right.
Because what a copyright is the right to copy.
Yeah. Yeah.
Really, I mean, in its simplest form, a copyright is the right to copy something. I created something, and now I have the right to exercise discretion over where it goes. So it
Gotcha.
sounds like now you created a methodology.
Yeah.
Okay, so now the methodology is going to probably fall into two potential areas, maybe three. One of which is if you've written it down, that writing that is a copyright. And
Okay.
so people can't just go about copying that, what that is, as far as saying, okay, and basically passing it off as their own. The question becomes, okay, what if they're not copying it, they're using it, right?
Right.
What are my protections for using it? It's not the expression of the idea that they're copying, which would be the copyright. It's using the idea itself.
Hmm.
And so usually that's why methodologies, formula, things like that, you either treat as trade secrets, which is we do this and we're not telling anybody how, but we do it better than everybody else. And obviously, if you've written it down and you're sharing it with people, then you're probably not covering it by a trade secret. So then the question becomes, if you have not made commercial use of it more than a year ago, is it original, new, useful, and something then that would make sense for you to try to get a patent on?
Okay. Um, but
Does
I
that
could,
distinction make
if I'm
sense?
licensing it as it stands, um, to those individuals who might be interested in replicating my process.
Yes, and you can license things that you don't have a patent on, right?
Okay.
You can just assert the right to, this is my original intellectual property. You don't have to say that it's a patent or anything else. You can say this is my methodology, especially if you give it a good trademark, right?
Yeah.
And other people want to say, I'm using this same methodology that everybody knows is a good methodology because it has this special name. That's how often branding comes into these things. You're doing something special in a special way. Good, it can be your own name. That's fine, right? But giving it a name, then you're saying, okay, I'm going to teach you how to do this. You're going to do it. You're going to pay me a licensing fee that either relates to revenues you have or is just a flat fee or whatever it is for the right to use it and to tell people that you're using it. So that they can basically say, "Oh, great, you've got the such and such method. Yeah, that's a better way of doing whatever it is you want to do. So yes, we're going to pay, a little bit more for your services, or we're going to take your services instead of somebody else's." So again, licensing is a very good way to protect anything that whether you're protecting your trademark in it, whether you're protecting an idea that maybe you haven't even patented, or it's a trade secret, or you're protecting something that you've got described in a document that is a copyright. Licensing is an excellent way because the more you license something as well, then if somebody else does it, it's like you can go when you're talking to a court, you're like, look, this is my original idea. I've protected it, and it's subject to all these licenses. That helps show your ownership of it and your protection of it as well. So, licensing is a very powerful way to protect really all of these types of intellectual properties.
Okay. Great. Thank you.
Yeah, absolutely. My pleasure. Good question.
I have a question.
Great, Marcus.
Let's say someone has a recipe for a food product, and someone says, well, that's pretty good, but I can make it better, and they change an ingredient. How would the court go about figuring out what percentage of the ingredient would have to be changed in a recipe for someone to go get their own whatever patent or
Recipes are really tricky because you can protect the sharing of the recipe. Like if you've got a cookbook, right? you can not let, you can prevent, and you put things down in a cookbook, you can prevent people from copying your cookbook, from copying your recipes, right? And using them to, basically saying, hey, this is my recipe or whatever it is, right? You can protect it by a copyright that way because you can prevent people from copying it. You can't prevent them from using it. In fact, the very idea of a recipe, right, is that it is meant to be used. So you get into, is this recipe really a formula? And is that formula then protectable by patent? And if somebody comes along and just makes a little addition or a little change to it, is that actually still infringing on what we call prior art? When you have a patent, you have to disclose all of your prior art, things that other people may have done that maybe were patents, maybe are patents, maybe were patents years and years ago, but that you've added some original aspect to, right? So people can, the question is like, if you have this recipe, it's actually a formula, you get a patent on it, and somebody makes a little bit of a change to it, well, are they still using your patent to do that? And is that infringing? Or do they actually have to license that right? And then the question is whether or not they've done something else that's new or different. But let's assume it's a recipe, a pure recipe, food, right? You can't really prevent people from making your recipe. You can prevent them from publishing your recipe, but you can't prevent them from making your recipe. In fact, as I said, the nature sort of a recipe, you want people to make it. And so the way you protect it is either through saying this recipe is not published, it is secret. It is the 7 herbs and spices. And the fact is, people can, it's okay to reverse engineer, or it's okay to do whatever, if they come along and they say, hey, look, I'm going to guess at what this recipe was that's in the trade secret, and I'm going to change it. That's okay. People can do that, which is why you want to protect certain things, again, with trademarks. So you want to be able to say, Kentucky Fried Chicken tastes like Kentucky Fried Chicken, and everybody knows KFC, right? Or KFC, right? Everybody knows KFC, and so we can call this KFC. If somebody is going to make up the KFC recipe and change it and make it into something new, they can actually do that, but they can't call it KFC. Or if you originally had a deal with them to be a KFC, and you had trade secret agreements that told everybody you can't use this special recipe, you know that it's special, and then you go off and create, Marcus's really good chicken, and it's the exact same recipe, and you're using their recipe, then you violated your contract with them under trade secret. So that's another way of sort of protecting it. But recipes, especially to the extent that people who are artisans in the biz, if you will, one chef to another chef or what, notoriously unprotectable because they are meant to be used, and frankly, changes are changes, and that makes it, a different thing. So unless there's a trade secret contract in place, or unless somebody's violating your trademark, or unless you have actually patented it, then simple recipes, they're most likely going to just not be something that you can actually protect. It's kind of the nature of recipes. It's a good question.
Hi, Joe. This is Claire Choi. I am working with some products where I'm leveraging some old traditional recipes that are very common out there,
Right?
using, what you're calling secrets to make it to a different level type of snacks. But so in my case, where it is fairly common, recipe known thing that's been around for a while. Am I in any sort, like, what is my
Yeah, right.
level of protection that I need to do and to
I
make
totally
sure
understand,
that
right? You're sort of the opposite side of the,
right.
hey, I actually want to take Marcus's recipe and change it a little bit and make it better.
Right.
Can I? And the answer is probably pretty much yes, especially if they're like old traditional recipes and you're putting a new gloss on it. Yes, I think you can do that without much fear of infringing somebody else's rights, right? Because I mean, one of the things about copyright, and recipes are not the perfect example of it, but you can defend against an infringement claim by saying, hey, it was fair use. So,
Mm.
like if you take a quotation out of somebody's book and you put it into an article that you're writing because you're commenting on that book, technically you're infringing that copyright, but your infringement is forgiven because it's a fair use, because it's in the public interest to have news reporting, to have criticism, to have comment, to have satire. You can copy things to make fun of them in America, which is pretty cool. So having, again, I don't think you're infringing in the first place, because you're creating a new recipe by using old ingredients. You're not publishing that recipe.
Mhm.
But that's it, in any event, to the extent that you're using prior art, that's just very ordinary, especially in the food world, right? I mean, people do that all the time. But know that once you've done that, anybody can do it to you too. And so
Yeah.
again, trying to protect it either through trade secrets, which is not, that's definitely foods are definitely a big area for trade secrets, or through trademark by putting a particular brand on something. So it's sort of like, yes, I mean, most colas don't actually taste alike. They do have distinct flavors, but you can have two colas that taste exactly the same. Well, for God, water. Water's a great example, right? Water's
Mhm.
water. Why are people buying Liquid Death? Because of its trademark. It's still just H2O. Maybe it's fizzy H2O, not talking about all of their, various, colors. But it's a pure trademark play, right? It's a pure marketing play. Their water is no different from anybody else's water. Evian's no different from Liquid Death when it really isn't. It's all about the branding. It's
Mm.
all about the trademark. So trademark really in these areas, in the food areas, or I'm creating something original and I want it associated with me, branding is almost always the best way to do that, and that's the world of trademark.
I see.
There's a
Awesome.
question
Yeah.
in the chat. Oh, Darlene, are you gonna?
I can't,
Oh, there's a
I'm not.
question in the chat. It says, "What's the difference between a recipe and a product formula? What if the ingredients are the same, but the process is different?"
Um, Frankly, I think a recipe and a formula are the same thing. I mean, a recipe, a formula, I think is probably just a fancy way of saying probably chemical, ingredients. This is how we're putting together these various chemical ingredients, and it can also be a formula that says, heat to a certain amount or whatever, or spin in a centrifuge, things like that. Those can be so. So there are sort of the ingredients that you might put in something. And so, I mean, I think we tend to use the word recipe, I think, in respect of food, and accurately so, and formula in respect of other things. But you could have the recipe for, in a sense, for a medicine, right? It's the same thing as the formula. So they're again, they're both protectable to the extent that it's new, original, and useful. And so if, again, if you've got a way of saying, look, I make my taffy in a particular way. First off, there's a particular recipe, but the second, I have a method that is unique. Maybe uses a certain invention or uses certain kinds of heating elements or whatever, to pull the taffy in a way that nobody's ever done before and is unique to me. That methodology, or the formula slash recipe for the type of taffy that allows itself to be pulled in this particular way, right? Whatever. I don't know why I'm using taffy. It was just what came to mind. Hopefully it's somewhat expressive. Those things theoretically could be subject to patent. I mean, for example, even though it was a mistake, ivory soap was originally patentable because you injected sort of bubbles into the soap, and they did it accidentally, but originally, and that allowed it to float. And for a while, ivory soap was the only soap that floated. because there was a patent on that methodology of putting together, whatever it was that was in that kind of soap, and then the bubbles that made it float. Now, after that patent failed, people still bought Ivory soap because it was a great trademark. It was a great brand, right? But the methodology to make floating soap, anybody could use that. So they all sort of interrelate and can come together in certain ways, especially around things like formulas and recipes and methods for doing stuff. And that's why it's helpful to what I want everybody to come out of here with is maybe the idea of, I think this might be that, or I want to make sure that I ask somebody about this other thing before we do something, because I'm now more aware of some of the intricacies of what value there can be in these various types of ideas and expressions of ideas.
Well, I do have another question, but I want to give other people a chance first. So,
Sure.
anybody?
Got a question. I've developed a methodology for harvesting live sea urchins, and we're in negotiations with a big company that is really excited about it because my survival rate is way better than anybody else has been able to do. And if this deal doesn't work out, how do I protect myself because we've got non-disclosures and stuff already in place, but once I tell them how to do it, then the value of how I do it kind of goes away, but they want to know it's kind of a trade secret.
And that's exactly it, right? I mean, at some point in time, in order to make deals, you got to tell people what they're buying. And that's really what a non-disclosure or confidentiality agreement is for. And that's why you want to have one that is, as ironclad as possible. That basically says, look, I am going to turn over to you, highly secret, confidential, proprietary information. And I expect where you actually see this a lot, strangely enough, because yours is a good example, but here's another one, the movie business. Somebody has a great idea for a show. Well, you got to tell somebody about that show. Yes, you can write it down, and that's a copyright, but that doesn't protect the idea. It protects the expression of the idea. So they could take the idea and change it and express it differently, right? And rip you off. Happens all the time. So you have to have the types of agreements in place when you go in to pitch somebody that says, you agree that what I'm going to pitch you is my original proprietary idea. If it turns out that there's nothing original about it and it was already in the public domain, fine. Then, you don't have to keep it confidential. But if it's true, what I'm telling you, that this is my original idea and it is unique, and you then, after we have this meeting and you've signed these agreements, violate that non-disclosure agreement, I'm going to sue you. And the damages are going to be the loss of the value of whatever contract we should have entered into to license this from me. And that's exactly what NDAs are for. And some NDAs are better than others. And a lot of people are like, oh God, do people put NDAs out over a ham sandwich? And they do, but that should not diminish the fact that in exactly your circumstances, a good confidentiality agreement, a good non-disclosure agreement are about the best things you can do before you walk into that meeting and then go ahead and spill your guts because you have to, right? It's only when they go, oh God, that is a good idea, that you're going to make the deal. But they've got to be in a position that says, and I'm going to have to make a deal with this guy because, I signed an agreement that said I would if I decided to use these confidential ideas that he gave me. And if I don't, he's going to sue me.
That's great.
Thank you.
Well, it's 12 o'clock, so I think we're probably going to start wrapping up. Is that correct, Joe?
Yeah.
Okay.
But I really appreciate everybody's time and attention. If you have other questions, you'll see there's contact information for me, for Rational Unicorn. don't hesitate to reach out. We'd love to be able to help you with some of the specific ideas or issues that you may have. And it's been my pleasure to be here, Marcus. I really appreciate it. And I really like the work that you guys are doing. And so would be, more than excited to speak to anybody about your ideas around this.
Great. Thank you so much for joining us, everybody. And thank you, Joe, for your sharing your knowledge.
Thank you.
Have a
Take
good
care.
Yep.